All right. Okay, we're going to get started. Hello, I want to welcome everyone. Thank you for joining the commercial lease negotiation webinar today. My name is Julie Gilgoff. I'm the staff attorney at Legal Services for Entrepreneurs, part of the economic justice team of the Lawyers Committee for Civil Rights. And we have my predecessor, Tobias Damler, joining us to share his expertise and experience as well. So this workshop is specific to Oakland, examining the commercial eviction moratorium that exists within the city of Oakland. So if you're from another jurisdiction, please see LCCR's event calendar for a San Francisco or San Jose specific workshop. And as a disclaimer, this presentation is not meant to be taken as legal advice. It's meant to educate and provide information about the protections of the Oakland moratorium, offer strategies and negotiation tactics to use with your landlord. So if you're looking for legal advice specific to your current situation, the Lawyers Committee for Civil Rights offers no-cost commercial lease consultations with our partner pro bono attorneys and contract attorneys. We'll discuss the application process of how to sign up for those consultations later in the presentation. So the agenda for our presentation today will first focus on the initial steps you should take before you start the negotiation process with your landlord, lease provisions to look out for so that you can enhance your argument when you are negotiating with your landlord. Then we'll focus on the provisions of the Oakland Commercial Eviction Moratorium as they apply to small businesses. And then Tobias will offer some tips for negotiating with your landlord, bringing in some of his experience of what has worked and not worked from the past. For questions, we'll pause in between each of the three sections, but you can write your questions in the chat box at any time. And Cristal Jones, our program coordinator, will collect these questions to pose to us during our breaks. So when you're getting ready to negotiate with your landlord, the first step is to review your lease. And when I say lease, I mean every part of it. Oftentimes there's a primary lease, and then there may be an addendum, appendix, different exhibits. So you just want to make sure you have the entire universe of lease documents to review. If you're seeking legal help from an attorney, make sure you locate and send each of these documents. If you sublet your space from someone, which means you have a sublease with the person who's the original tenant, and they have a master lease with the owner or landlord, you want to review both your lease and the master lease, which may include provisions that affect you as the subtenant, which may not be included in your sublease agreement. If you've leased your space for multiple terms, if you renewed your lease, you'll want to review each version of the lease that you signed. Oftentimes there's an option to extend without signing a brand new lease document, and it's the original lease that you've signed that might contain helpful terms and provisions that I'll now discuss. If you don't have a lease, this is a good reason to sign up for a commercial lease consultation. Your protections under the moratorium are going to depend on your agreement with your landlord and prior negotiations. Not having a written lease might give you options to terminate if that's an option that interests you. So as you review the written lease, there are specific terms you want to look out for. You can look out for these buzzwords and identify these provisions so that when you come to your consultation or initiate a talk with your landlord, you'll already have a head start. One such term is common area and other expenses, often referred to as CAM expenses, and sometimes denoted as additional rent. You may argue that since the common areas were shut, your landlord didn't have to incur any expenses to maintain the shared spaces, and then you shouldn't have to pay any of these costs. So I had the experience of working with a client whose landlord was trying to pass capital improvement projects to the tenant, which is prohibited under CAM expenses, and also even the electrical costs with installing exit signs to keep the building up to code, which should not be included in CAM expenses. So the bottom line is if some of these costs under CAM seem fishy, if they seem too high, especially given that the facility was closed for much of the year, you have the right to ask your landlord to see an explanation and also talk to an attorney. You want to also look out for abatement terms. These are provisions in the lease that allow you to decrease the rent paid in the occurrence of certain circumstances, like if you can't access the building or if your landlord is cutting off services like utilities. So see if there's any mention of abatement and make a note. On the contrary, there might be a lease provision stating that the landlord won't be liable for disruptions. So then you wouldn't make these arguments. Also keep your eyes out for the words force majeure, which literally means acts of God. A force majeure clause would excuse you from having to pay rent if there was an unforeseeable catastrophic event, and we would make the argument that the pandemic fits into this category. In terms of commercial frustration of purpose, if your lease states that the sole purpose of your leased property is to conduct a certain type of business, like a hair salon, auto repair shop, or a restaurant, and it wasn't possible to open your business because of government mandated shutdown, this is another argument why you shouldn't have to pay rent, at least for the time that the shelter-in-place order was in effect and the business was completely closed. If you see any provisions that guarantee your right of access to use the premise, that would be another possible reason why you shouldn't have to pay rent during the months when access was denied by government orders. If you see a condemnation or casualty provision, which are extremely common in California, especially in San Francisco because of the prevalence of earthquakes, this may be of use. These provisions were meant to apply to physical damage to the property, like an earthquake or if the building burned down, and answer the question, would a tenant have to continue paying rent, or would they be able to terminate the lease? Some condemnation or casualty provisions could be interpreted to cover a loss of access or use during the government shutdown. If you're in a building with multiple commercial spaces like a food court or a shopping mall, there might be provisions in the lease that require the landlord to meet certain obligations, like maintaining a level of occupancy. This might be additional grounds for rent reduction if the landlord didn't maintain the occupancy requirements. Also, keep your eyes out for the term quiet enjoyment rights, which means that you have the right to inhabit your space free from recurring disruptions or disturbances. If there have been significant disruptions or disturbances created by the landlord, this would be helpful to your case. Also look at the provisions regarding security deposits. There's usually language in the lease outlining when a security deposit can be applied to missed rent, and when a security deposit must be repaid to the landlord. So our suggestion is to review these provisions to understand how the security deposit might be used for rent repayment. When negotiating with your landlord a rent repayment plan, you might want to incorporate the security deposit as part of your proposal if you're having a hard time making the back rent that's accrued. So once you've reviewed your lease documents and looked out for these keywords, you're going to want to reach out to your landlord to start the negotiation process. It's really important to establish an open dialogue. Written communication is the best way to prove that you've attempted to engage in negotiations to come up with a repayment plan or reduction of the total rent that's owed. If you're not paying rent, it's important that your landlord know the reason that you're not able to pay the rent, such as pandemic-related financial hardship, like a loss of earnings during the pandemic because of reduced hours of operation, complete closure during certain months, or your own illness during this time. And each month that you can't pay rent or the entire amount, it's important that you reach out to your landlord to explain the situation again, even if it's the same reason as last month, and even if the landlord is not responding. Cristal will be circulating a form letter along with a sample repayment plan for you to write to your landlord and tell them that you've been unable to pay rent or due to pandemic-related financial hardship, and use these forms as the basis for a written agreement if you find that helpful. And this information will also, those forms will also be available on our website, I believe, starting next week. And that's lccr.org, or whatever the written address is that we'll present later. And these slides themselves will also be sent to you individually. If your landlord counters your offer with another proposal, you should continue to respond, stating why their proposal is or is not feasible. You might want to offer a rent scheme that takes into account your actual earnings and pays a percentage of that amount, although there's no legal obligation for your landlord to accept anything less than the whole amount. If the landlord asks for accountings and bank statements to prove your financial hardship, don't feel pressure to show them all your bank statements. Instead, you might show them a QuickBooks accounting of gains and losses. You might assert that it's irrelevant whether you've received government assistance or loans, as you're not asking of the landlord what government assistance it has received. Make sure that you gather all relevant paperwork and begin the negotiation process with your landlord, making and keeping copies of all relevant paperwork, emails, texts, scans of letters, and your lease in one consolidated place. To elaborate on this point, even though it might be self-explanatory, you might scan a copy of your lease and all the appendices into a folder on your computer. You might take screenshots of the text messages with your landlord, saving them in this folder as well. A scan of any written letters that you've mailed to your landlord should also be kept. Save copies of voicemails as audio files. You might need a special app to save voicemails, so look into how to do that ahead of time on your phone. But really think it through if you've recorded every type of communication with your landlord to document the outreach that you've made to initiate further negotiations. So we'll take questions now before I discuss briefly the Oakland moratorium provisions. Cristal, are there any questions to the best of your knowledge? Or does
No,
anyone
no
else
questions have come up yet. Please feel free to use the question and answer tab or the chat to pose a question.
Okay, great. Thank you. And if anyone has questions as they come up later in the presentation, just put them in at any time. So now these are some details about the City of Oakland commercial eviction moratorium. Oakland's eviction moratorium is tied to Governor Newsom's statewide executive order and any extension. And as the heading states on this slide, local protections around California and in Oakland specifically, it currently extends through June 30th, 2021. So that's coming up, and this date may or may not be extended. We just have to wait and see. So the moratorium protections apply to commercial and other small business tenants with 100 or fewer employees with an average annual gross receipts of $15 million or less over the previous 3 years, as well as nonprofit organizations. The moratorium protects qualified businesses and nonprofits from being evicted for non-payment of rent due to a substantial decrease in income caused by COVID, which can be documented. It does not obligate the landlord to accept any rent reduction, and any rent accrued during the pandemic must be repaid. So again, the loss of income must be substantial. That's not explicitly defined, and it must be documented. But as I said, if it's not in your interest to show all your bank statements, don't feel pressure to, as long as you can document it in some way. So this means that any rent missed through June 30th, 2021 could be due on July 1st, 2021, except if you negotiate with your landlord another agreement to a longer repayment plan. In San Francisco, Tier 1 businesses have 2 years to repay rent, but this sort of provision doesn't exist in Oakland, so it's really up to you to negotiate. Your landlord can agree to additional extensions past July 1st in their discretion. One important thing to bear in mind is, even though it seems like your landlord has all the power in demanding the full rent under your lease obligation, they also probably want to avoid bringing you to court if they could help it, to save the investment of time and money in court fees, let alone the uncertainty of how courts will rule during this time when most businesses have had trouble meeting their rental payments. So if your landlord has a stake, so your landlord does have a stake in reaching a plan for repayment of rent that works for both of you, even if it doesn't seem like that in their communications and they're just trying to bully you. This is the last slide of this section, emphasizing that now is the time to start negotiations with your landlord while the moratorium is still in place. Your landlord can't evict you for missing payments during the period of the moratorium, and we would recommend working with your landlord to come up with a written repayment plan that works for both of you. And again, we'll follow up by providing a template rent repayment plan, the slides of this presentation, and a form letter that you could present to your landlord stating that you've experienced pandemic-related financial hardship. And are there any questions about the Oakland moratorium? August, you raised your hand? August, are you able to, are we able to hear you? I'm not sure what's happening. Crystal, would you mind reading the chat to see if there's any questions that are being written out?
Yeah, I can do that. The question is, when can landlords take us to court for eviction?
So my understanding is that at the end of the moratorium period, which right now would be July 1st, 2021, they can initiate an eviction proceeding against a commercial tenant. Tobias, what's your understanding?
That's my understanding as well. If there's unpaid rent that remains due after on July 1st, 2021, then they can initiate an eviction proceeding.
August, does that answer your question, or do you have a follow-up? And I'm sorry, we can't hear you.
I think there may be a way for participants to unmute themselves.
August just added that the old rule was that Oakland would start seeing eviction cases after 3 months. Post-moratorium.
August, that's really helpful if you want to copy the link of where you're finding that. That would be helpful to everybody. But Tobias and I don't believe we came across that provision. I know that Alameda, the city of Alameda, has something like that that restricts the a certain number of days after the end of the moratorium, but I haven't seen that specifically for the city of Oakland. Were you aware of that, Tobias?
I wasn't aware of that, but yeah, August, like Julie said, I'd welcome you to share the link as well.
Yeah, because we think that it's immediately after ending. They could start the proceedings. And if there's no further questions, Tobias, would you like to start the next section?
Sure. Thanks, Julie. And thanks everyone for listening so far. I'm excited to be with you here today. I'm going to present to you some general tips about lease negotiations during this time with your landlord. So as you all might know and might have experienced already, the first step in negotiating, oh, thanks for advancing the slide,
Sure.
Julie. The first step in negotiating is to get your landlord to come to the table and negotiate. You know, some landlords try to use just radio silence in response to tenant requests to negotiate as a pressure tactic, but don't be intimidated by that. Just keep trying to contact them. And one helpful tactic, if they keep not responding to your requests, might be to contact your City of Oakland council member to see if they can contact your landlord on your behalf. I haven't had experience personally with that in Oakland, but I've seen that work in San Francisco, where a business contacted their San Francisco city supervisor, and the supervisor got the landlord to come to the table to negotiate. Next slide, please. And then when you're preparing to negotiate with your landlord, it's good to prepare an ask for your landlord, like a starting ask during the negotiations that's realistic for you, because you want to avoid setting your business up for failure in the future, and you want to avoid repeated renegotiations as much as possible. So for example, you know, the landlord might be asking you to commit to paying full rent moving forward, and 50 or 75% of the back rent that you owe over a number of months, and then to also agree to not have any further amendments to your lease. And that could actually be detrimental to you if you can't really afford to do that, and if you know, God forbid, there's a lockdown in the future because of some variant that's resistant to the vaccine. I hope that doesn't happen, but you know, you never know these days. So you want to make sure to start the negotiations with a request that is realistic to you, and to make sure that you know what you can realistically agree to. And you know, just take a hard look at where your business revenues are at and where they're likely to go in the coming months in order to prepare yourself that way. Next slide, please. In addition to being realistic, don't be afraid to ask for the moon. So don't be afraid to make an ask that totally benefits you at the start of the negotiation, because a lot of the time the landlord will start with an ask that totally benefits them. And so if you both start at your respective starting points and then sort of go more towards the middle, you can try to find common ground and try to find a solution that works for you both. But most landlords start at a request that totally benefits them. So it benefits you most of the time to make a request that benefits you, even if you think it's not realistic that the landlord will agree to it. And they may say, you know, they may try to intimidate you and say like, oh, that's totally unreasonable, and you know, I'm not negotiating with you anymore, or something like that. But that's just to intimidate you, and you can then come back and say, well, what about this, and sort of move more towards their end, you know. So some of the things that you can ask are abatement of rent, or being allowed to not pay rent for however long the pandemic is going on. Extended deferrals of rent beyond the end of the moratorium. So being able to pay the back rent that you owe, or sorry, not pay the rent that you owe for several more months or 6 months or a year after the moratorium ends. And also you can request an extended repayment period for the rent that you were not able to pay during the shutdowns. And again, this is where the repayment plan template that will be distributed after this this presentation may come in handy. You can look at that template and sort of try to mold it to the request that you want to make, and give it to your landlord to start the negotiations. Next slide, please. Thanks. Some other requests that you can make are to convert the rent that you owe, so the back rent, into a loan that's payable over a fixed period of time with a certain interest rate maybe. You can also ask the landlord to use the security deposit that they have on hand that you paid previously and credit that towards the back rent that you owe. I had a client once who was able to negotiate termination of the lease in return for letting the landlord keep the security deposit. So that might be a realistic option for you. And then also a forgiveness of a certain amount of the back rent that you owe, possibly paired with a promise to pay the full rent moving forward if you think you can afford to do that, because then that's sort of like a gesture of good faith towards the landlord, that, you know, you're giving up something and then they're also giving up something. Next slide, please. So another request you can make is if your lease term is about to end, you can consider asking for an extension of the lease, sorry, you can consider asking for an extension of the lease to give you more time to pay the back rent that you owe. And you know, your landlord might have asked you already, or they might ask you in the future, what assistance are you receiving in terms of government funding or nonprofit or financial institution funding, relief grants for your business. And if you get that kind of question, you know, you can say, well, that's irrelevant, like Julie mentioned, or you can also ask, it's fair to ask then, what kind of assistance is the landlord getting, so that you can have that information as well and factor that into your negotiations with the landlord. The key is that neither the landlord nor the tenant can bear the full burden. And they basically, in these negotiations, people always, if the negotiations end up in a resolution, like a way to resolve the dispute between the tenant and the landlord, both parties give something up and both parties should share the burden evenly, and also depending on each party's ability. In addition to making asks at the beginning of the negotiation that may be unrealistic for the landlord, but you know, you can make them as a starting ask. You also want to keep in mind that you shouldn't overcommit. And this sort of ties into making sure that you know what's realistic for yourself. So one thing to ask for that may satisfy some of the landlord's needs, but also prevents you from committing too much, is repayment of back rent tied to a percentage of your monthly revenue, instead of some set monthly amount that you're not 100% sure you can pay going forward. So you might be able to come up with this figure, like this percentage, by looking at what your base rent was in 2019 before the pandemic hit, and then dividing that by what your 2019 monthly revenue was. And then when you get that percentage, then you multiply that percentage by your current revenue and see, you know, whether that would be a realistic amount for you to pay each month right now. And if so, you could propose it to your landlord. You could also just ask your landlord to convert your obligation to pay a certain amount of base rent per month, so like a fixed amount of base rent per month, to a percentage rent. So like a certain percentage of your revenue or your net revenue after expenses for the entire term of your lease, or for like a longer term. So the first option I talked about just now was like seeing like repayment of back rent tied to a percentage of your monthly revenue. So like how much of the back rent can you pay each month? Okay, so like you see how much revenue you're earning, and then decide based on how much revenue you're earning, how much of the back rent you can repay. And then the second option I just suggested was tying the actual amount of your monthly rent going forward to how much revenue you're earning per month. I hope I was clear about that, but if you have any questions afterward, I will prompt everyone to ask questions, and you can ask questions then. Next slide, please. Also, I just want to add that some landlords find that, or think that if they're verbally abusive or threatening, then they can get what they want, unfortunately. So if your landlord behaves this way, the best advice is to communicate with them only as much as needed. And I don't think that the city of Oakland requires any kind of communication in its commercial eviction moratorium for the tenant to meet certain legal requirements. So just communicate with them as much as is needed to, you know, keep negotiations going, and just keep asking them to negotiate, or, you know, keep them up to date about your situation, but nothing more than that. Next slide, please. And just adding that some landlords, as you all might have experienced, are nevertheless trying to sidestep the commercial eviction moratorium by filing lawsuits claiming, you know, breach of contract, and just asking for the total amount of back rent that is owed as a pressure tactic. And if you encounter this, then the best thing to do is to get an attorney to represent you as soon as possible. These lawsuits, fortunately, generally have a 30-day period in which you have to file what's called an answer, or a response to the lawsuit once the landlord files it, because they're not eviction lawsuits, which generally have a response period of just 5 calendar days. But as soon as you get notice that a lawsuit has been filed against you, take a deep breath and try to find an attorney as soon as possible. And if you contact Legal Services for Entrepreneurs, they may be able to refer you to an attorney who can help you, not necessarily provide you with pro bono or free assistance, but they may be able to refer you to someone who can help you. Next slide, please. So what comes next? It's important to watch out for announcements about when Oakland and Alameda County will move from the orange tier to the yellow tier as reopening continues. There's a link there that you can see when each county moves from the orange tier to the yellow tier. Next slide, please. And as Julie mentioned, Governor Newsom's 2021 executive order extends cities' ability to extend their eviction moratoriums through June 2021, but we don't know if the governor's order will be extended, which will then give cities the ability to extend their own moratoriums. So we still need to wait to see if that will happen. Next slide, please. In terms of business interruption insurance, some of you may have heard of being able to use business interruption insurance to get reimbursed for losses during the pandemic. Court decisions on this have generally been unfavorable, but it largely depends on each policy's definition of what's a qualified business interruption. And there have been some court decisions that are business owner friendly, but the insurance companies have appealed them. So we'll have to wait and see how those turn out. Next slide, please. There's a link here on this page to the latest grants and loan programs for Oakland businesses on the City of Oakland's website. And there's also an email address that you can email if you want to get in touch with someone at the City of Oakland who supports local businesses. Next slide, please. The Paycheck Protection Program application remains open until May 31st, 2021. There's also a coalition called the Independent Restaurant Coalition that had until recently a grant program for restaurants that had experienced hardships during the pandemic. The application closed, but they're lobbying for more funding from Congress. So go to saverestaurants.com if you're a restaurant and check that page regularly to see if they've replenished their funding program. And then there's also a link to the Oakland Business Assistance Center where they have the latest updates on funding sources, and you can actually subscribe to notifications for updates. Additional assistance, if you want, is available through Lawyers Committee for Civil Rights, Legal Services for Entrepreneurs. Legal Services for Entrepreneurs can provide you with a 1-hour remote consultation by phone or video chat with a volunteer attorney to look through your lease and talk about your situation and some ways that you might be able to negotiate with your landlord, or if you're negotiating right now, ways that you might be able to move the negotiations forward. There's also a limited amount of longer term negotiation assistance available for small businesses experiencing difficulties with their commercial lease. You can apply for it at tinyurl.com/LSE application. And now we're going to open it up for questions again. Thanks, everyone.
There's no additional questions in either the question tab or the chat.
Okay, I see August still has his hand raised. I'm not sure if that was from the previous question round.
Yeah, I think that was from the previous.
Okay, just making sure. Just giving everyone another minute or 30 seconds or so for questions. All right, well, if there are no more questions, I'll hand it back to Julie to close us out.
Okay, and I'll actually defer to Cristal, I think. Well, I wanted to emphasize the way, thank you so much for joining us today. And if we will post the recording of this webinar. If you know any other small business owners who are interested and need these resources, please forward it to them. And as well as the template forms that we'll send to each of you individually. We actually have a clinic coming up this Thursday that Cristal, would you be able to explain to everyone how to sign up if they'd like a slot to meet with an attorney for a 1-hour consult?
Yeah, we actually have 2 spaces available for this upcoming clinic on Thursday, the 27th. It starts at 4 p.m. So the spots, one is available at 4 and the other one's at 5. If you are interested, I am putting the link in the chat so that if anybody who is available and interested, you can definitely register. Again, there are 2 spots, and also feel free to send me an email if you have submitted your registration.
Thanks, Cristal. And so you'll also put in your email address? Great.
Yeah.
Yeah, there's a typical referral process at LSE for new clients undergoing an intake and then trying to match with an attorney. But if you have an emergency, we're also looking into ways to meet client needs, including, as we discussed, responding to a complaint if a lawsuit has been initiated against you. So we would like to, be of service to this community of small businesses in Oakland, and please don't hesitate to reach out and apply for our services. So thank you so much again for joining us.
Oh, we have a question. My insurance company's lawyer reached out to me. They're asking me what payout I'm looking for my claim. My current lawyer strongly recommends I now get a lawyer who specializes in these types of legal cases. Does LCCR help with this?
I think we talked about this the other day at a meeting, right, Cristal, about we don't have a specialization in dealing with insurance itself, but as it's tied explicitly to your lease and the rent that you owed, do you think, Cristal, that August should reapply for our services?
Yeah, and we can conduct an intake and get a little bit more information from you, August, to see if this is something we can assist with.
So anyone else, please feel free to email Cristal. And Cristal, our general email address is just lse@lccrsf.org, right?
Correct.
Okay, so I'll write that in the chat as well.
And we will make sure to share the recording of this and any other substantive information that we will send that to you all via email.
Okay, thanks everyone. Have a great afternoon.
Thank you.
Thank you.